property law is a very interesting and developing field, especially when it comes to how things are defined. We are speaking to one of India's leading IP lawyers, Mr. Praveen Anand, who's the managing partner at Anand & Anand. So thank you very much for speaking to India today. We're talking about this very new aspect of IP recognition, which is smell marks. And this is something that has happened for the first time in India. And you were the amicus in this matter. The Trademark Registry has recognized a smell mark. But could you explain for our viewers, sir, how does that work exactly? How does a smell, a scent get trademarked?
So, at the end of the day, a trademark is nothing but a source identifier, something other than the goods, which may be a symbol, it may be a word, it may be a color combination, it may be a number, a numeral. Today brands are so prevalent on the internet, in real life. People go and purchase with reference to brands. So a trademark, which has got to be something which is a source identifier. Now, when it comes to trademarks, normally you have traditional marks, which are normally words and logos, geometric devices, etc. Or you have non-traditional trademarks. Non-traditional trademarks are like shapes, like the Birkin bag of Hermes, or the Ferrero Rocher chocolate, which has a crumpled wrapper placed in a tray. That's a shape mark. Or a Zippo lighter, the shape is unique. Or you may have, in a non-traditional mark, you may have sound marks, like the Yahoo Yodel and various other sound marks. You suddenly hear a sound and you know that's Netflix the moment you switch it on. That's very peculiar because you immediately recognize the service or the goods with reference to that symbol. And that's the function of a trademark.
So now we have come to a situation where a particular tire company has registered a smell mark, a scent mark. So could you explain to us, sir, what went into this litigation?
So at the present moment, their application has been accepted for publication in the journal, which itself is a big achievement in the Indian context, because till now, amongst all the non-traditional trademarks, shapes were there, color combinations were there, sounds were registered and protected, but there was no smell mark. And so this is the first time that that's been allowed and for advertisement by the Trademarks Office.
Is this something that is a very unique thing? Are there other smell marks or are there other definitions of smell marks in other jurisdictions outside of India?
There are, but not unique at all, not common, quite rare. So for example, a classic one was tennis balls that smelt of freshly cut grass. That was protected by the European community as a smell mark.
So if you could explain for our viewers, sir, when you talk about defining a trademark, you have to explain just what that aspect of that particular product is. How exactly does legally, if you could explain for our viewers, how does one define a smell? I mean, you can say that freshly cut grass smell for the tennis ball, but how do you define that smell when it comes to this, particularly when this comes to this new fragrance, the smell of rose in a tire that you're talking about? How do you define a rose?
Correct. So there are two types of smells. Smells that are impossible to define, like the smell of, let's say, a perfume. You can't verbalize it. It's impossible to describe what that smell is. But the second kind of smells are those that are kind of recognizable because of our experience of smelling an object on a day-to-day basis. You have a lot of strawberries. Everybody knows the smell of strawberries. So if you describe a smell as, let's say, ballpoint pens that smell of strawberries, that smell is recognizable by the word strawberries. Or the smell of a rose is recognizable because people recognize the smell of a rose. They are
But
familiar
that
with
is
it.
not what has happened in this case,
But
right?
in this case-
You've created a new way of defining.
Correct. And the reason was because the registry, the Trademarks Office, the Controller General and the Trademarks Office felt that you needed to go beyond just using the verbal description, rose. You needed something more. And that's the reason why we made an effort to try and find a scientific way of describing a smell. And so what was done essentially was to break down the smell into its component smells.
Okay.
And as you probably know, there is a theory known as the stereochemical theory of odour, according to which theory, all things that have a smell consist of molecules with peculiar shapes. They may be elongated, or they may be circular, or they may be triangular, pyramidal, and those molecules go and fit into the olfactory region of the nose. They go and fit into receptors which correspond to those shapes, and then that creates the sensation of smell in the brain.
Okay.
And those 8 or 9 different kinds of smells are the elements that make up all other smells. So like 26 alphabets make up words, similarly those 8 or 9 would make up every kind of smell.
So you figured out
we
a way to
broke it.
define that smell.
So we were able to break it down. So we are able to say 45% floral, 10% putrid, 5% camphoraceous, like that. So the moment you are able to put that on a radar diagram, you know exactly what smell you're talking about.
So if there is a situation where now that you've created this kind of mapping has been created, you were appointed as the amicus curiae by the Trademark Registry to exactly do this exercise of mapping this particular smell, or how to create a smell mark. What does this then mean now for the larger IP world? Not just in India, but across the world, because as you said, it is not easy to define a smell. You can say that a product smells like a rose, but which rose are we talking about? Which kind of smell are we talking about? What does this mean really for the larger IP world?
So it means 2 things. First and foremost, a lot of people would like to explore smells for their goods or services, and that opens a new pathway to protection. That's one. And second, they'll have to think of how exactly to graphically describe the smell that they've selected. If they choose a smell which is easily identifiable, perhaps the jurisprudence might develop further to say that a verbal description of that smell is good enough. If, on the other hand, they choose something which is a little complicated, like which rose, things of that kind, then they might have to break it up into its components and describe it with reference to a diagram which has a percentage of the various components that comprise the smell.
So does this mean that, and I'm throwing this out as a very layperson question, there are certain very well-known perfumes in the world. If you tell somebody that A lady was smelling of the Burberry Red, or B lady was smelling of Chanel No. 5, they will know the smell you're talking about. But those scents themselves, can they now be trademarked, the scent per se, by this mapping?
See, as they say in law, never say no, but by and large, prima facie, that would be a descriptive or a generic trademark for the goods that have smells.
Okay.
So, you're not, like, for example, if somebody tried to register the color red for lipsticks, then that deprives the trade of using a color which is a natural and apt description for the goods. And so, in that sense, it will not be protected either as a trademark or registrable under the law.
Okay.
being descriptive or generic. Similarly, if you have perfumes, they have their own smell, and you cannot therefore register a smell, or you will be probably a giant task to register a smell for a perfume, as it may not acquire distinctiveness so easily. I don't say no, because it may well be that there is a peculiar, highly peculiar and distinctive smell, which is something like a pink colored bag moving on a conveyor belt, where from a distance you can make out that that bag is yours,
Yeah.
right? Which means it's so distinctive that it stands out amongst all the others. So if there is such a smell which stands out from all the others, maybe it might be protected. But by and large, for products which don't have a smell, like a pen or an eraser or a book cover which has a smell of a kind, and the owners of that product, when they manufacture and sell it, they want to promote that smell as a source indicator.
As something distinctive about
Distinctive
that
of them,
particular product.
Of that, no, not of that product, as much as of the company that brings out that product as
So,
a source
in
indicator.
this particular case,
Yes.
you were representing you were the amicus in this case.
Yes.
So, in this particular case, we've seen a tire company getting a trademark for a particular line of tires that smell of roses.
Yes.
Which, I mean, for anybody in general, will not associate tires with the smell of roses.
Correct. Totally arbitrary.
Completely arbitrary. So,
Yeah.
is that why it is possible to then create a smell mark for a product that isn't ordinarily connected to a smell?
Absolutely. In fact, like you have generic and descriptive at one end, on the other end you have distinctive. And the most arbitrary trademarks are on that end, of being highly distinctive. And being distinctive, they can be protected.
Alright. So just to sum up this entire, if you could just sum up what this means for, say, an IP student or somebody who's practicing intellectual property, does this now also offer an opportunity worldwide for people to expand their trademark protections?
First, I think the most important thing is that it shows the flexibility of the Indian legal system in accepting something which most countries have not yet accepted or have not reached that level of protection for trademarks. That's the first thing. Second, it shows the role of an amicus curiae. And I think as going forward in a lot of proceedings in courts and tribunals, there's going to be a lot of reliance on experts or amicus briefs, where you can get a third-party view, a neutral view on complex issues. Third, the combination of science, arts, law, all together, that interdisciplinary approach for students. So students should not just, who are doing law, practicing law, should always think of how we can use a technical solution, how we can bring in philosophy, how we can bring in things from other subjects. And I think that's going to be the way forward. And in that sense, it's an excellent example which illustrates some of these very fundamental principles.
All right. Thank you very much, Mr. Anand, for speaking to India Today. It is a very exciting new development in the intellectual property world. Indian Trademark Registry has recognized a smell mark, which, as Mr. Anand was saying, was created mathematically, scientifically, with inputs from three IITs, with inputs from Mr. Praveen Anand himself, who is a chemistry student in his college days. So it is an exciting new development that we are looking at, and India is showing the way to the world of how IP law can change and grow. In New Delhi, this is Anisha Mathur for India Today.